Verbal agreements in Texas. Are they worth the paper they're not written on? While a handshake deal might seem simple, the legal reality is far more complex. Let's explore the enforceability limitations and legal remedies surrounding verbal agreements in the Lone Star State. In Texas, verbal agreements can indeed be legally binding, provided they meet certain criteria. For a contract to be valid, it must have four essential elements: an offer, acceptance of that offer, a meeting of minds where both parties understand the agreement similarly, and consideration, where each party receives something of value in exchange. However, not all verbal agreements are created equal. The Texas Statute of Frauds places significant restrictions on certain types of contracts, requiring them to be in writing. These include real estate transactions, agreements lasting more than 1 year, and contracts for the sale of goods valued over $500. This legal safeguard aims to prevent fraud and misunderstandings in more complex or high-value agreements. Proving the existence of a verbal agreement can be challenging. Without a written document, courts often rely on other forms of evidence. This might include witness testimony, related correspondence like emails or text messages, payment records, or proof that one or both parties have already begun performing their part of the agreement. The behavior of the parties involved can also be telling. If they act as though a contract exists, it strengthens the case for its validity. Despite the limitations imposed by the Statute of Frauds, there are exceptions where verbal agreements can still be enforced. Partial performance is one such exception. If one party has significantly acted on the contract, such as making payments or delivering goods, courts may choose to enforce the agreement. Another exception is promissory estoppel, where a party reasonably relies on a promise to their detriment. When a verbal agreement is breached, the non-breaching party has several potential remedies. They may seek compensatory damages to recover financial losses, restitution to be reimbursed for services or money provided, or in rare cases, specific performance, where the court orders the breaching party to fulfill their obligations. In situations where no enforceable contract exists, a party might still recover fair compensation under the principle of quantum merit. To protect yourself when entering into verbal agreements, it's wise to follow up with written confirmation. This could be as simple as sending an email summarizing the terms discussed, keeping transaction records involving witnesses, and where legal recording conversations can all help establish the existence and terms of a verbal agreement. In conclusion, while verbal agreements can be legally binding in Texas, they come with significant challenges and limitations. Written contracts provide stronger legal protection and help avoid disputes. When it comes to important agreements, it's always best to get it in writing. Remember, a clear contract today can prevent a costly court battle tomorrow.